Good evening, this is Joe Millay from Watchdog Swim Protection Services. Welcome to tonight's podcast. This episode focuses on Judge Richard Lindsay of Kanawha County. In less than a year on the bench, he's already shown a troubling pattern, ignoring due process, misstating the law, and shutting down cases without giving citizens their day in court. This is not what justice looks like, and the people of West Virginia deserve better. I filed my complaint properly. The defendant was served and ignored the case for more than 6 months. Under Rule 55 of the West Virginia Rules of Civil Procedure, that means default judgment should have been entered. I filed it not once but twice. Judge Lindsay refused to act. Instead, he dismissed my case without hearing a word, without any evidence, and without a jury, taking away my constitutional right in violation of Article 3, Section 10 of the West Virginia Constitution, which guarantees due process, and Article 3, Section 13, which guarantees the right to a jury trial. That's right, these judges are dismissing our cases even though we checked off the box for jury trial. Completely illegal. The U.S. Supreme Court has made it clear in Logan versus Zimmerman, Brush Corp. 455 U.S. 422 in 1982, that due process requires notice and a meaningful opportunity to be heard. Judge Lindsay gave me neither. He also twisted default law, claiming defaults only survive in the complaint if substantive or they're non-frivolous. But as the Supreme Court explained in Connolly versus Gibson 355 U.S. 41 in 1957, a complaint should not be dismissed unless it appears beyond doubt that the plaintiff can prove no set of facts. Once default occurs, allegations are taken as true. That's the bottom line. Once you default in a case, the individual who did the default, that chose to not respond, they are putting out there where they are not willing to fight or protest their innocence. That's on them. It's not your responsibility to do that. It's their responsibility. Judge Lindsay also claimed he has to act in the state can grant relief. That contradicts State Ex Rel. Hinkle versus Black 164 West Virginia 112 1979, where the West Virginia Supreme Court held that circuit courts must act when properly invoked. His statement about writs mandamus that they must be filed in a higher court was also false. In State XL Kruger versus City of Wheeling 153 West Virginia 538 1970, the court made it clear that the writs of mandamus can begin in the circuit court to compel a judge to do their duty. Look, we understand that's probably not the best way to do it, but you can do it. It's not grounds for dismissing your case entirely. In fact, it's not grounds to dismiss your case at all. The court case I had today was about the defendant not responding. She's in default. So why is this judge turning this into a trial in that he's stating that at the end of the day, he's going to dismiss my case in its entirety? And he has a writ of mandamus against him that he has to deal with Judge Hardy, who's overseeing that, but he's not even taking that into consideration. All this comes after unprecedented attempt by all 8 judges, county judges, to recuse themselves from my cases, leaving me without a judge at all. The Supreme Court denied that attempt, reaffirming in Caperon versus 18 Massey Coal Company 556 U.S. 868 2009 that judges cannot avoid their constitutional duty when impartiality is questioned. Now Judge Lindsay's actions look like retaliation rather than intentional or not. The result is the same. My filings are buried, my rights ignored, and the public's trust in the courts undetermined. Judge Lindsey has only been on the bench for 8 months, but already the warning signs are clear. If judges ignore due process and bend the rules to protect themselves or their colleagues, every family in this county is at risk. The Constitution, both state and federal, demands better West Virginia courts have long held. In State XL Peck versus Gaynor, 148, West Virginia, 555, 1964, that the right to be heard is of little value unless it is preserved in practice as well as in theory. That's the principle at stake here. This is why Watchdogs Family Protection Services, because, you know, they're not following the law. So watchdogs, we're watching them. We're trying to get it out there that the court system here in West Virginia is just absolutely ridiculous. These judges are making up the rules as they go. They're prolonging cases by canceling them. You know, I've had one case they've literally dismissed 3 different times without one word being mentioned in court. 3 times, the same case. They're violating our constitutional rights. Judge Lindsey has done that on this case. He did it on another case we had about 3 weeks ago involving a corrupt prosecutor. You know, where does this end? Where does this end? I mean, what he should have done today, and at the most, is dismiss my motion to address the fact that the defendant is in default judgment, because that's all this case today was about. No, he couldn't do that. He couldn't do that because he lost that massive, you know, unified case that he filed in the Supreme Court in relation to having all the judges recuse themselves simultaneously. He was unsuccessful in that. So he goes to the next step. Hey, you know what? If I can't do it that way, I'm going to do it this way. I'm going to make up some stuff that I know he's not going to buy, but it'll delay the case for another 6 months or a year. I'm going to make up some stuff that it literally makes absolutely no sense. But at the end of the day, this man will leave this courtroom this day with the same amount of money he came in with, because the defendant is at default. It's not a large default. It's for $100,000. But the bottom line is she chose to not respond, because what's been happening for the last 3 years, she has been being protected by the judges, CPS, guardian ad litem, and the attorneys. And they know that. These judges, these circuit court judges in Kanawha County, they do not want me to go to any of their courts and prove my case, because if I did that, it's going to make them look bad on the cases involving my son that they've already ruled on. I mean, they are really going to extremes to make obvious lies up about, you know, filings and how they're filed and who they're filed to. And I mean, this is it's a red herring is what it is. It's a red herring. They're trying to divert the thought from reality to their fictional life in which they live. And believe me, and I say this to everybody out there, and you really need to understand this, there's only one way these judges, guardian ad litem, CPS workers, civil servants, you name it, there's only one way they're going to stop with this garbage. And there's one word to describe that. It's called accountability. Believe me, without accountability, we're dead. I mean, just imagine Lindsey making these ridiculous findings today, literally dismissing my case with no cause, never hearing the case. And by the way, I'll reemphasize, there's a jury trial request. He turned it into a bench trial. Imagine him doing that, okay, thinking about it overnight, because guess what? If accountability is true, the next day someone's calling you up and say, what are you doing? What, are you kidding me? What's wrong? Are you okay? Punish him. Take away his bench for a month or so. Fire him if necessary, if it's continued. Unless we are willing to make that next step where these people are accountable for their actions, we are never going to move forward on this movement. It's just not going to happen. They're not powerful because they're smarter than us. They're powerful because they cheat. And that's what I told Judge Lindsey to his face in court. The only reason you're winning is because you're cheating. And you know what? He didn't respond to that because he knows I'm right. He knows I'm right. He used the analogy of a card game, Uno, where in Uno, you pass out 7 cards each individual. So let's say, for instance, you pass out 7 cards to one person, 3 cards to another, 5 cards to another. That's not going to be a fair game, is it? And I said in reply, Your Honor, that's exactly what you're doing. That's exactly what you're doing. What we're trying to do, we're trying to even up the playing field. You're cheating, not me. I wish you gave the same amount of cards you got dealt, but you're not doing that. You're not doing that, and you're not going to do it unless you are accountable. So this is short as well. I'm trying to continue with these shorts. I like them. I seem to have a better response off them. You know, at the end of the day, I mean, what are we looking for? We're looking to have justice take place. We're looking to have our children returned to us because under these circumstances, it's outrageous. They're taking our children away with absolutely no evidence whatsoever. And when you fight them, and believe me, I have been fighting them, and I'm going to pump up the volume in the very near future, that's for sure. But that being said, I mean, that's all we're looking for. Why is it so hard to find justice? I just can't figure it out. And this isn't just in West Virginia. This is in your state. This is happening where you live. I don't care if you're in New York. I don't care if you're in Illinois. I don't care if you're in California. I don't care if you're in Texas. It's happening in your state for the same reason, no accountability. So obviously we have a gentleman named Mike Stewart. He's a senator in West Virginia. He's been given a very strong opportunity to voice his opinion at the level of the White House. He's going to be inducted hopefully in the very near future. He is definitely pro-accountability and transparency. He made that claim a long time ago publicly. If he gets in, okay, there's a very strong possibility this could be a national situation where he can resolve it nationally, because we're not going to get this done dealing with the state courts. They're a joke. Now, the upper courts, the appellate courts, and the Supreme Appellate Court and the Intermediate Court here, they seem to be serious. They seem to take care of business, but they're complicated. Not everyone can do them, especially pro se, but I am. We're just trying to get a fair deal. If it takes the higher court, and that's another thing that bothers me, is why does it have to take the higher court to get justice? Why can't we just get justice at the level of circuit in the first place? Why can't you just be a good person? Why? Why do you have to be so hard-assed? Why do you have to be so tough on people? Why do you have to punish innocent people like me as a grandfather and other grandparents? Only for the simple reason you can. Then you put the burden on them to prove that they're a quality person. I don't have to prove to you I'm a quality person. I have to prove that to myself every day when I wake up, and I do prove that to myself by my conduct. Not even so much as a parking ticket. And you guys are treating me like I just got out of prison for 30 years for mass murder. It's unreasonable. It's unacceptable. Well, that being said, what I'm going to do is I'm going to make we are not anti-CPS. We are definitely not anti-family court. We're not anti any kind of structure, situation. Well, we are 100% pro-justice, and we're not going to stop until we get justice. Thank you.